Morning. The first case to come before the court this morning is William, is it Besancon? Besancon, and versus Cedar Lane Farms Corp. App.No. Each party will have 15 minutes in which to present your case. The appellant may retain up to 5 minutes for rebuttal. If you're the appellant, you want to retain some of that time. Let me come up when you come up to the podium. Let me know I'm keeping track of the clock or keep your price of the passage of time. We are being visually and audibly recorded and posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Good morning, Your Honors. My name is Ryan Barnard. I'm here on behalf of the appellants, William and Sandy Besancon. I'd like to reserve 3 minutes for rebuttal.
Thank you.
If it may please the court, we're here today following a trial court's judgment and after a trial in this matter that was appealed by Cedar Lane Farms. There was a notice of appeal that was filed in the underlying case and a motion to stay by Cedar Lane Farms. There was a hearing on that motion to stay the judgment back on September 3rd, 2015. That was journalized on September 4th of 2015. The court, prior to issuing the supersedeas bond in this case, heard arguments from counsel, and after that determined and set the supersedeas bond in this matter the amount of $25,000.
Was the argument raised there that the bond should be sufficient to cover not only the conversion action, but loss of use of the and rental of the farm property?
Yes,
that argument was made to the court.
The argument was made to the court. I don't believe that there was any journalization of that. However, after the argument, both sides, the court clearly took those arguments into consideration because the $25,000 is actually five times the judgment amount. The conversion was $5,000. So we believe, and it's our position, that after the court heard our arguments, the court had understood that because of the situation involved in this underlying case, it was really a landlord-tenant matter. We had rented certain property to Cedar Lane Farms, and there had become an issue over when and how that lease ended. Basically, what happened is that our position was found to be the proper one by the trial court, and it was appealed. Now, during the appellate process, which the supersedeas bond had placed a stay upon, my clients were unable to use this portion of land that the trial court had found that Cedar Lane Farms had no interest in.
Can you go backwards and tell me what your prayer was in the complaint?
The original declaratory judgment action.
What did you ask for in your pleadings?
I believe, I don't recall, to be honest, Your Honor, exactly what our prayer was at that point, but I believe it was, as far as this appeal is concerned, it was a declaratory judgment action that Cedar Lane Farms had no interest in what we were commonly referring to as the North Field. This was the property that we were talking about in the underlying lawsuit, which also became subject then of the appeal. So we were asking that the court declare that there was no rights there. The court did that. This court affirmed that decision on appeal. So what we had was really a long period of time here where Cedar Lane Farms had filed their stay. It had been granted, set at $25,000. We believe the court did that, multiple of the judgment, understanding and knowing that my clients, the appellants, would be out of possession of that property. They would not be able to use it. They would not be able to, more importantly, rent it out, produce income from it. And the property basically sat idle during this stay. Now, once the court had affirmed the decision, I filed a motion to terminate the supersedeas bond and also for a release of the entire $25,000. And when we did that, we placed into in our motion that my clients had sustained damages, mainly fair market value, lost rent, and we expected to at least have a hearing or at least a judgment entry that determined somehow that we had no damages.
Did you ask for a hearing?
I did not ask for a hearing.
You anticipated it?
We anticipated it because it was at least in my opinion at the time, it was implicit in the judge's original entry. When you're taking a $5,000 judgment and making it $25,000, the judge is understanding that there's going to be damages. And the long and short of this, Your Honors, is that we did not get a hearing. And reviewing, I wanted to make one other point in clarifying. On page 8 of the appellee's brief, they state that the trial court considered the Besancon's arguments for damages. I don't see anything in the entry that mentions the word damages. The entry that we're appealing, it's simply the appeal is done, Cedar Lane gets, the Besancons get their judgment amount, $5,000 plus interest, and the balance goes back to Cedar Lane Farms. There was never any consideration in that judgment entry that I can see that the court even considered the damages.
Well, is that perhaps because the nature of the bond, the supersedeas bond, which is to protect the judgment, in this case $5,000?
We also, Your Honor, that's correct, but we also believe that in this case, due to the fact that the court heard arguments prior to setting that bond amount.
And set at $25,000.
Set $25,000.
I get your argument.
Set $25,000 for a reason.
Mm-hmm.
I don't have anything further at the. Thank you.
Morning, Your Honor. Today, please support my name is Doug Trushel here on behalf of Cedar Lane Farm. I'd like to first turn the court's attention to the motion to dismiss which we filed in this case. The court took that under advisement and said it would be addressed at the same time as the merits. So I want to start with that because motion to dismiss is granted, then we're done. And I believe the motion to dismiss is well taken. The matter is moot. The question involved here is what to do with the $25,000 that was posted by Cedar Lane Farm. It's already been dispersed. Cedar Lane Farms has cashed its check. Mr. Barnard made much of, at the time, and I don't know what the case is today, they made much of the point that they haven't cashed their check yet. Well, they can't control what the clerk does. The clerk has dispersed the funds. If the action here is what are we supposed to do with the $25,000, what's left for the clerk to do? They've given out the money.
I have a question. Is the issue before us really whether or not those funds were dispersed or whether there is a separate right to damages during the time of the appeal?
The only issue in their assignment of error is that they said the court should have held a hearing. That's it. So they didn't ask for it, as we have pointed out in our brief, and as Mr. Barnard has conceded. That's the only issue. Now, I suppose implicit in that is what would the hearing have been about, which gets you to the question of damages perhaps. But if the funds are dispersed already, it doesn't matter because there's nothing to fight over. If there is a damages claim, the damages claim that he's asserting here was not, we get back to Judge Teodosio's question, it was not in the complaint in this case. There is no such claim. And even if it had been, it doesn't really matter whether it's in the complaint or not, even if you could imply it somewhere. It wasn't in the judgment. This case went to a trial, went to a judgment, came up to this Court of Appeals, and the judgment didn't say anything about damages for loss of use. And so there was no reason that the bond would protect against that because that wasn't something that was ordered. And Mr. Barnard says, well, it's implicit that that had to be meant by Judge Wiest because the bond amount was set higher, meaningfully higher than the $5,000 judgment. Well, that ignores the fact that Judge Wiest's decision included more than just the $5,000 judgment. There was a reformation of the lease issue, for example. This court reversed Judge Wiest on that issue. And so that's no longer there. But my point is that there was logic to rounding it up more than just a double, for example, and $25,000 still isn't all that much money. And there were other things that Judge Wiest ordered that the bond could have protected. This court reversed on that. And so those went away. And the point being, you can't infer anything from the dollar amount of the bond. The courts, the cases and the civil rule is very clear that the dollar amount for a bond is completely discretionary. Judge Weiss could have set the bond at $1. It's very common for judges to grant stays with no bond, just have to address it. And so the fact whether it was here it's $5,000 or $10,000 that covers some interest or $25,000 is really meaningless. It would be highly inappropriate for this court to infer anything from that. And that's all that Mr. Barnard is saying. It must be implicit that that was suggested. I'd say that's not the case. There are other reasons. And it is highly improper to make an inference, say, well, this must be what he meant, and therefore we're creating a new cause of action that wasn't in the complaint and wasn't in the judgment. So for those reasons, we believe that the motion to dismiss should be granted. In the, I think, unlikely event we get to the merits of the case, that still the judgment should be affirmed. As I mentioned earlier, the sole issue presented was whether or not a hearing should be held. There is no law that suggests that there should be a hearing. It's not in the civil rule, it's not in the statute. I found no case law. Mr. Barnard has cited no case law that says a hearing had to be held. The standard before this court is abuse of discretion, as the court is well aware, I'm sure. To say that it was an abuse of discretion to not hold a hearing that wasn't asked for and that isn't called for in statute or case law or civil rule, I would submit is incorrect. Mr. Barnard, in his opening brief, made much of the difference that he perceived between an appeal bond and a supersedious bond. As we pointed out in our brief, there is no such distinction. The civil rule that talks about appeal bonds calls it a supersedious bond. The terms are used interchangeably. The sole purpose of this bond was to protect against the judgment. The judgment was two things. It was number one, it was a $5,000 judgment, and it was the reformation of the lease. As I mentioned, the reformation of the lease got reversed, so that went away, but the $5,000 judgment got affirmed. I didn't like that, but that was, so be it, that was affirmed. It was paid. That was the purpose of the bond. The bond was actually, in actual fact, used, those funds were used to pay the judgment, and the appeal bond served its purpose. It did its job.
So can he file a separate cause of action for his claims for loss of use?
I think he could. I hate to encourage him because he likes to keep this case drawing out until he's ready to retire. And I'm older than he is. But yeah, I think the answer to that is yes, which is another reason that this appeal is so crazy, really. It doesn't get him anything that he can't otherwise get. If he is...
He's drafting his complaint right now.
Pardon me?
She said he's drafting his complaint.
Yeah. I'm sure it's already on the word process. But the point is, if it wasn't in the prior complaint, and even if it was in that prior complaint, it wasn't in the prior judgment, well, anything that's happened since then hasn't been litigated. And if he thinks he's got a damages claim, so be it, file it. That's why this appeal, even just as a practical matter, doesn't make any sense. He cited in his reply brief the case of Tutor versus PNF Enterprises, a Cuyahoga County Court of Appeals case. But that case, if you read it, it actually supports our position in this matter. In that case, an appeal bond was posted. It was an eviction action, so rent was accruing. And so you don't, and the tenant stayed in the property pending the appeal. So you don't know how much rent is going to be owed until the appeal is done. And the municipal court, in that case, it was a municipal court case, determined, okay, here's the amount that should be taken out of the judgment, or out of the appeal bond, rather, for the rent that accrued, and the court costs, I think, were included. And the rest goes back to the party that posted the bond. And they appealed that, and the Court of Appeals said, yeah, that was correct, because they were trying in that case to say, well, no, there was also a loss of use, or the property, there was a diminution in value, there were some other things that the property owner tried to say should be covered by that bond. The Court of Appeals said, no, no, no. This is a case for rent. The bond was to protect the rent, and that's all you're getting out of it. If there are other damages like loss of use and so on, that's not to come out of the bond. And in that case, in an eviction case where you're seeking damages, the type of damages you're seeking, can come out of the bond. So for example, if you had damaged the property and you weren't entitled to get your whole security deposit back in an eviction type lawsuit, that could come out of the bond, and that would be damages, but it's damages arising out of the claim that you're making in the complaint. Here, this is not, the $25,000 is not money coming, or not protecting a claim in the complaint, because this issue wasn't in the complaint. It's something that would be brand new. If, let's assume, for example, this hearing had been held that Mr. Barnard is asking for, what would have been presented? You'd have to have a new trial. Well, where's the, you'd have to have discovery on that. You'd have to have depositions and expert witnesses or whatever you would need to determine, what, if he's claiming it was a rent or loss of use and that kind of thing. Well, you got to have evidence on that. It makes no sense, just as a practical matter, to say that that's something that should be taken out of an appeal bond that wasn't posted for that purpose. So, as I mentioned, I think the primary answer here is the motion to dismiss should be granted, but even if we get to the merits of the case, Judge Lee's decision should be affirmed. Thank you.
Thank you. Yeah, 5 minutes.
Thank you. First of all, Judge Callahan, as to your question as to whether this is an issue regarding the disbursement of the funds from the clerk, I don't think it is. We didn't have any control over that. The clerk did what the clerk did when the judgment entry came down. What I will point out in the record is that we timely filed a motion to stay that. I believe we filed that just 3 days after the court's ruling was journalized, and by that point in time, the funds had been dispersed. We'd also like to point out that in the record there is an affidavit from my client, Mr. Besancon, that he has not in fact cashed the check and still has not cashed the check. So I don't think this appeal is moot. I'd also want to just address you, Judge Teodosio, with in regards to our actual prayer at the beginning of the case. Mr. Druschel has made some day out of the fact that we didn't plead this in the beginning. Well, certainly we wouldn't have known that this case would end up in a year-long appeal process whereby our clients would be, or my clients would be unable to use a portion of their farm that was in dispute, and they were successful in winning that portion of the trial. So we would have been unable to, I think, determine.
So that claim wasn't ripe at the time?
That's what we would be saying, yes, Your Honor. We would not have been able to file that. I wouldn't have had any idea that would have existed. Also, as to filing a new lawsuit, is that possible? Certainly, I think in this case, certainly maybe to Mr. Druschel's chagrin, I have no interest in filing more complaints. In this case, it's been going on for, I don't know, maybe 5 years, or I can't even remember. But it seems to me to be a grossly inefficient process to file a new complaint when here we had a sufficient supersedious bond. Our position is, again, that it was to protect for damages to the successful litigant as a supersedious.
So how would you
bond.
determine those damages, though?
Well, we were going to have a hearing, and I was going to have my client testify about past rent that Cedar Lane Farms had paid. They had been paying, I believe, $200 rent. That would have been probably the bottom of what we would have asked for in damages. It would have been the fair market value of lost rent.
Does your argument have the potential to have what I would, this might be a little extreme, but what I would call a chilling effect on appeal? If I want to appeal a decision, should my decision to do so have to, weigh in, but wow, I might have to pay more money now, I might be responsible for this delay, what if it takes the court 18 months? Should that even weigh into it, and would it, based on?
Well, I think that is a concern for some litigants, but certainly we're here, I think, and as far as looking at the statute, when you're ordering a supersedious bond, you're protecting a plaintiff who has won in the court below. And I think the trial judge would be the one thinking about those things and setting what we would call, or what we would hope would be, a reasonable supersedious bond. So I think there's a gatekeeping function, I guess, at the trial court level. We would also like to point out that the Cedar case, or however that's said, from the 8th District case, or from the 8th District, that's a landlord-tenant matter, as we perceive this to have been. And I don't think anything in our brief and in our argument today is asking the court to extend this to other types of situations. We may have a unique situation here where it is a landlord-tenant action, and it's very similar to the case that we cited, where that's protecting the landlord while the tenant appeals, because the tenant's still in possession. The same thing that happened in this case.
So back to the hearing. You're suggesting the court set a hearing, but set it out far enough so that discovery can be had on these other issues.
If that's what would be required.
And is there any authority for the court to, that requires the court to have a hearing, I guess is what I'm saying?
Other than this 8th District case, I think that's very similar to what we have here. And I don't know whether this is an issue that generally doesn't come up because it's determined in the trial court. I don't know, but there are not a lot of appeals cases on this other than what we believe is one on point out of the 8th District.
Thank you.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be posted to our website and to both parties. Thank you both again for being here today.